Okay, I'll start.
The
Good evening,
recording is-
everyone,
Just a
and
second.
welcome to our
Go ahead.
Good evening, everyone, and welcome to our webinar, Bengaluru Citizen Clinic, Decoding Property Documentation, your guide to sale deeds, Kata, EC, and more. Before we begin, I would like to give this disclaimer. This should not be considered as legal advice. It is a general discussion on certain issues related to property and documentation. But should you seek specific legal advice, please get in touch with an expert for the same. With that, we extend a warm welcome to our guest, Mithun Gerahalli. Our webinar today will be moderated by a community anchor, Sandhya Bhatt. Before that, I would like to say whoever's joined the live stream, please feel free to put your questions and comments in the chat box. We will take it up towards the end of the webinar. Mithun Gerahalli is an advocate and solicitor specializing in matters pertaining to revenue, property, real estate, civil constitution, service, commercial companies, and arbitration. We are looking forward to him answering questions today. I would like to take 2 minutes to tell you about our work, since some of you may be new. Citizen Matters is a civic media platform that serves as a knowledge exchange with insightful reports on critical urban issues, ideas, and solutions for cities, diving deep into issues which affect our quality of life, including water, commute, public safety, air quality, governance, education, environment, local economy, and more. We bring together civic media, data, and diverse voices to help citizens build sustainable, equitable, and livable cities. We provide in-depth information and insights on various critical urban issues to facilitate understanding and the tools for citizens to become change makers. With that, I would now like to hand over the event to Sandhya. Thank you.
Thank you, Shravasi. Welcome, Mithun.
Thank you.
Investing in real estate market in Namma Bengaluru can feel like a game of whack-a-mole. As soon as you address one property issue, another seems to pop up. It's an ongoing challenge and certainly not entertaining, to say the least. We have been bombarded with queries on the documentation and such, so we decided as to why not crowdsource some of these niggling questions, whether it is due diligence or post facto, handover, etc., and get an expert like you to answer them. So the first question, let's start with the beginning, due diligence.
Well, it's my pleasure being here and just trying to see if we can find some solution and answers to the questions they've asked. So we can move on.
Thank you. So let's get into the due diligence part, for which a new buyer should be doing. What are the documents should a new buyer look for, and how should it she or he get it verified?
Firstly, it's a very vast question and an ocean of answers to reply. So let it put it this way. So firstly, if a person is buying a property, it depends if the property is a survey number, an agriculture property, or it's a site, or if it's a BDA allotted site. So it depends on the character of the land or the property that they would purchase. Why this would be the centric aspect is, if it's an agriculture property, then the title documents, what they require for an agriculture property, would be different from a list of documents that they would require to see if they're buying a site. So, for example, generally I would put it across this way. Any property you're buying, generally you need to look at the owners and trace the title of the ownership of the land. If it's a land, if it's a site, then trace the title of the land where the site is formed in. So at least look at 40 years of tracing of title. Look at getting an encumbrance certificate just to see if the title deeds do reflect in the encumbrance certificates. Then look at other relevant documents such as Kata extract or RTCs if it's land, to see if the name of the owners are reflecting in the RTC, Pahani, or the relevant Kata extracts or e-panchayat documents. So that would be one relevant aspect. Then the second aspect is to see if it's a revenue land, then the source of land that has been is it a nature of a granted land, or is it a land that is purchased by its sale deeds? If it's a source that is apart from sale deeds, then other aspects that needs to be looked into is whether it's granted land, under what specific provisions it has been granted, and what are the conditions, if there is any applicable to that grants. If it's a sale deed, then prior sale deeds needs to be looked into, whether the tracing of title leads to the original land being a sale deed, or it's again a granted land. So it's very important that you see these basic documents, so that you understand that what you're buying has got a perfect marketable title. So apart from these documents, there are other documents that we need to look at is taxpayer receipts. If it's a layout, then you have to see whether it's a converted layout, if it has a sanction plan. All these aspects do have a bearing, because then ultimately when you purchase the land or the site, if it's a site, then you need to see whether it's a legally formed layout, so that you have a Kata or a e-Kata, and it's also funded by any of the banks as a project loan, and maybe also look into the any opinion provided by the such banks, so they can also cross-refer your verification. So basically there's so many intricacies that may get involved, but this is what I would suggest as a basic primer to looking at one should look at or consider when they're buying property.
Getting a checklist probably very well. You mentioned Kata. So this is a very contentious issue. There are a lot of litigations, and the impacts, as you mentioned, the ability to get housing loan does get impacted with certain types of Kata. You mentioned Kata extract. What is it? And what is this A Kata, B Kata quagmire all about?
See, what happens in Kata is basically Kata is a document, nothing but a tax assessment which reflects the name of the owner, area, the property number, and also the location, as well as the address. Anyone looking at the Kata basically is looking at who is the current owner of the property, and also what is this tax assessment for the property. So it basically gives an idea of who is the owner, and what's the size of the property, and what's the area of the property. So Kata generally is for a site, and if the site is within, let's say, in a BBMP jurisdiction, then ultimately it has to be issued by BBMP, that's Bengaluru Mahanagara Palike. If it is beyond the BBMP jurisdiction, then it has to be issued by, if it is coming within the panchayat limit, then it has to be issued by area concerned panchayat office. So basically, these are the documents. This is the Kata that you would get if, for example, currently common term that floats around people's mind is A Kata and B Kata. So basically, there is not exactly what a term called B Kata, but it's what happens in BBMP limits is, for the last couple of years, a lot of sites have got a tax assessment done, but those properties maybe are not a legal property. It may be an illegal layout, it may be a revenue layout without a conversion, or maybe without a layout plan. So those properties where they have not accepted an officially betterment charges cannot be recognized as a site in accordance with law, that is being formed in accordance with law. So BBMP have started registering illegal sites and just putting them in a B register. So the B register has now been commonly termed as B Kata. But though there's recent judgments of the Honorable High Court of Karnataka, which says there is no such distinction of A Kata or B Kata. If you're collecting taxes, then you as well as give A Kata. So I think the recent government has taken a step forward to pass a bill, because an earlier attempt to regularize these layouts which are illegal, people have bought maybe sites from some developers or from individuals which may not be a legally formed layout. So in such circumstances, they may not have a kata, which is a e-kata or a legal kata. So the government has taken a step forward now recently to see if we can regularize those katas by accepting betterment charges. So I think further orders are awaited on those aspects. But an earlier attempt made by the government, I think the Akrama Sakrama scheme, where they wanted to regularize unauthorized layouts, kata buildings, that has been stayed by the Honorable Supreme Court. So that attempt has been stalled. But I think it's time that the government takes some steps soon, which is also being done on the revenue side, where now they've abolished all other katas except for e-kata. And I think they've also updated that in the Sakala, which is called e-asti. So there is no other katas except for e-kata, and that e-kata has to be issued in accordance with law. So hopefully all these things should be in place very soon.
So this e-Khata is applicable to all municipalities like BBMP, Panchayat, etc., or how is it?
Yeah. So what happens is see, all this comes into picture when you're registering the property. So earlier, I think the software, even I think I'm not quite sure, but I think they're making an attempt to rectify those loopholes. So earlier they had an option to register e-Kata, as well as there was an option of other options. Other options was opening up with katas issued by Karnataka Housing Board or BDA or any such other authorities which have formed the layout. So they should register these sites, by referring to other options. But I think now they plan to do away with that other options in registration and just have e-Kata. And if it's e-Kata, it has to be approved online, and they're also doing away with manual options. So if it's e-Kata, then it is obviously need to be applied online. And if it's online, there will be certain parameters, like, if it's a layout that is formed, then it may ask for a layout plan, it may ask for conversion. And if you don't have those, conversion or layout plan, you may not be able to get e-Kata at all. So henceforth, they're also trying to get, some kind of criminal aspect to deter, developers from forming such unauthorized layouts, so that this whole issue of illegal layouts and illegal katas don't exist in future. So they're trying to make some attempts. Hopefully, it should sort out.
So this e-Khata is for prospective buyers, or retrospectively people who have already bought properties should apply for e-Khata as well, or how does it work?
It's basically that the bill that they've introduced recently is also to cover all illegal layouts or illegal buildings or illegal sites. So they want to do away with that whole Form B or Type B, or the second type of these katas that has been existing and floating around, where people are collecting taxes. That's the whole point of what the Honorable High Court said. I mean, if you're collecting taxes, you might as well regularize them. But technically, then you're allowing all the illegal layouts and buildings to be regularized at once. So it's a cabinet decision that needs to be taken. And I think once you take, I think they need to regularize everything what's there, but also put an end to further replication of these issues, so that you do away with the current illegal sites or layouts or buildings, and future ensure that these things don't crop up again. So it is partly yes, but unless the government regularizes those illegal layouts, you're not. I think the existing people who are having the katas which is not probably in accordance with law, they may not be able to do it unless the government regularizes the illegal layouts. Going forward in future, obviously it all depends on how they buy it and where they buy it from. Hopefully it should be from an approved layout and approved source.
So is this different from the UPOR?
I'm sorry, I couldn't hear it.
This property card which they are coming out with, they've been doing urban property ownership records project. I mean, is this a part of that, or?
So another pilot project, that is the property card, is partly, yes, to also to ensure that these properties what are there are being surveyed, and an online identification have been given. I think going forward, they're not going to speak. They are accepting property documents to ensure that they are registered as a particular property in the records. But I understand if you don't have any records, then it will be difficult for them to register your particular property. So at some point, it requires to also streamline existing unauthorized buildings and layouts to to get some kind of documentation, so that these officials who are going around collecting documents have some documents from these illegal layouts or illegal buildings as well. But otherwise, imagine if there is some illegal building without any property documents, it would be difficult for them to conduct a survey and put them on record. So they need to fill that gap, and I'm hopeful that these bills that are being sought to be introduced will fill all these lacunas.
Okay. There was a question on the one-time settlement, the property tax arrears. It's been in the news for some time now. So
Right.
this time, government has given a bit of a leeway. I think in February or March, it was announced that they will give a one-time settlement. So there is a query on whether this will help obtain a Kata for a flat which has no OC, because a lot of them have been paying property tax, living there for many years without an OC in apartments. So do you think it's a
that needs clarity, and on three different aspects. So collecting arrears of tax may not be entirely on legalizing a particular building. It could be there's some SSCs who have not paid taxes for a long time, or who have not come under the proper tax assessment, or may not have properly declared entire taxation of their building. So what that entails, and the scope of and the ambit of that tax arrears needs to be looked into. But prima facie, I doubt the scheme that would be opened up would also regularize katas, because there are two different aspects. Collection of tax arrears is different from regularizing illegal buildings or illegal taxes, but they may overlap. It may require for buildings without any documents to first regularize and get some documents and then pay taxes. So it would be irrational to ask a building without any documents to pay taxes. And that is what the Honorable High Court says. If you're collecting taxes, then you rather regularize it, or you don't regularize. You take a stand.
So, you mentioned about a family tree. So there is a query on what should be done if the builder does not have seller does not have a family tree or the land documents due to multiple past transactions. So a lot of these lands gets fragmented over a period of time. They pass several hands, and given our method of documenting or the lack of it, how does one look at such properties?
See, considering our Indian system of how lands have been passed on from ancestors, the source of land and origin of land in India is very important, because you don't find this probably in other foreign countries or other international countries. The concept of joint family, is very intrinsic to Hindu law, as well as this concept of ancestral property is also very interesting to Hindu law and also to Indian system. So what happens is, when the other members or a joint family members have a right in the property, then it is then incumbent that when you're buying a land, is to be looked into whether it's a joint family property or it's not a joint family property. If it is a joint family property, then it is very essential to understand who are the members of the joint family. Then to understand the joint members of the joint family, then one needs to look into the family tree. So Recently in 2006, there is an amendment to the Hindu Succession Act where women have been given equal rights. So a lot of instances have been there where women previously have been omitted from the family tree, and that would actually be very dangerous to title, because if someone has purchased a property without looking into these aspects, then obviously they will have an issue with marketability. If should there be any family members missing from the family tree, and that may lead to unnecessary litigation and maybe also hindrance in marketable titles. So it is very important to see look into the family tree, especially if you're buying these lands which are of a joint family property, or has occurred to you in a tracing of title that these may be essential. But it may not be essential if you're looking at, if you're buying from a BDA. Obviously family tree doesn't make any sense. But let's say if you're buying as a second purchaser from a BDA allotted site, then a second purchaser may require to look into family tree to see whether the property that is purchased is a self-acquired property or it's a joint family property. So it also depends on from whom you're buying, at what point of time you're buying.
Okay, so under BDA, there is a query. The owner claims it's a Kata property. The property is mentioned in the owner's name, and the owner has valid registration papers, but the RTC mentions the owner's name as BDA. Is that an issue?
See, I think that may be a very specific question. I think there's a lot of facts that needs to be looked into. What I understand and comprehend from that issue is, a lot of times, especially in Vayalikaval society or the Akavati society, there are issues where certain lands are contested by the landowners, or at the level of the government notification, where initially it's notified under the acquisition and subsequently it's dropped from proceedings, either by way of denotification by the government or by way of some court proceedings. So what happens there sometimes, let's say at the level of High Court, at the single bench, the matter is left at denotification. Or tomorrow someone goes and appeal and says the matter cannot be denotified, or the subject matter of land cannot be dropped from proceedings. In these quandaries, what happens sometimes, the landowners would have again gone back to the revenue officials by giving some earlier orders to show that the land is left from the proceedings, and he gets a revenue entry. Then what happens? Let's say BDA gets an overturn of the order, but sometimes these revenue entries just proceed. So in these circumstances, there will be some inconsistencies between the Pani and the claim of BDA. So in those specific circumstances, it's advisable for them to seek further advice and carry out meticulous legal tracing of those case laws or the cases that may have occurred by the landlord, so that case history and litigation of that particular land between BDA or the acquiring authority requires to be looked into.
So there's one more question similar to this. What does a buyer do when they have sold a plot which is under development and part of its land is currently under litigation? You mentioned Arkavati and other plots. There are some layouts which have come up, which builders have taken and developed, and plots are sold. They may be, these dual, some may be legitimate, some may not be. How does one look at, how does even a person verify these things?
It's very difficult to answer, every aspect, covering every aspect of what you just raised. As I said, depending on the situation, what you're coming across, it's a site or a land. If you're buying a site from a developer, it's very important to see if the developer has all the approved plans, approved conversions. All of these aspects needs to be looked into. So I recommend the first thing anyone looks into these, even thinks of buying a property, first thing, please seek proper advice from an expert in real estate matters. So because each of it has different connotations, what you're buying at what point of time, from whom you're buying, and what you're buying. So a lot of things may vary, but in simple, I would say that, if you're buying a site from BDA, look at, whether BDA right to allot and sell, whether that, that particular notifications have been challenged by the landowners, and whether it has attained finality or if there's any pendency of appeals. A lot of times what happens, a lot is think that they're buying from BDA, but they wouldn't look into the aspects whether the litigation has attained finality. A lot of times they would have won a matter in favor of BDA. The landlord would go and approach an appeal after some time and got a stay subsequently. So it's very important also for the BDA to take right steps to disclose and also have a disclaimer in these kind of matters. But unfortunately, allottees always end up in the conundrum of litigation between BDA or the acquiring authority with the landowners. So it's very important that they verify that litigation has attained finality or not.
So we looked at the due diligence part. Now let's go to the other side where people have already bought properties. And here the city is expanding, both horizontally and vertically, which makes property issues that more complicated. Let's see if we can simplify some of them. So there's a question on what are all the documents I need to have after I purchase an apartment from a developer and government department. This is basically handover documentation in an apartment.
That's completely different now from what we have spoken. So that's another gray area that is existing in Bangalore, especially. There's, it's actually a very difficult, task that a lot of apartment purchasers face because there is not a very easy way of enforcing the handover process. It's quite a cumbersome process of handover, but I think it's time that some amendments are brought in place regarding handover. But the RERA does provide for the process of handover, but the process of approaching and the self-compliance of finding developers during the process of handover, especially the tier 2, tier 3, tier 4 developers, is very difficult. You will probably find that all smooth in the tier 1 developers, but not entirely. But going down the order, you'll find the handover process very difficult. So there's not a single checklist that is given out under a statutory act that says this is the list of handovers. But normally what you need to see is firstly that particular apartment is registered under the Karnataka Apartment Ownership Act by way of a deed of declaration. Secondly, whether there's an association in place. Thirdly, the list of documents that is promised to be handed over is handed over to the association. So it's a task which both the association has to look into and as well as the buyers. So, and if you're looking at handover, then you need to see that the land-related documents, the project-related documents, approvals, and the structure and building-related documents are in place and handed over to the association. And if they're still in the process of handing over, then they need to see if there is a specific undertaking in your conveyance deeds, such as sale deeds, which provides for such an undertaking from the developer that they would do that handover in due course of time.
So, from the government side of things, I think there's hardly any due diligence or government oversight in most of these things. So after registering an apartment at the sub-registrar's office, is there any paperwork to be done to ensure transfer of land, the UDS portion, to the buyer? This is KSRA registered apartment. Unfortunately, there's a large number of associations registered under the Karnataka Societies Registration Act, which it is not supposed to. But these are builder legacy issues which people have been unaware, have bought property some 20, 30 years ago and existing to live and all. They pay their property taxes on time and things like that, but still stuck here. So how do they proceed? What can be done?
Well, see, a lot of times what has happened, the developers have handed over in as is condition to the purchasers and they've left. And, by the time they go back, the builders would reply saying that, we're no longer existing, we're no longer in place, we have no idea, it's too long, we've done the handover, but we need to figure it out itself. A lot of times, people are in a state of situation, they're not able to get any answers from the builders. So this is the process usually that should be set in motion by the developer or the promoter of the project. I think the first things first is the government has to ensure that without setting these two aspects in place, they should not allow the promoter to exit from the project. And they should, add in some additional criteria which allows, doesn't give a promoter an exit without complying with these two primary aspects. I think if they can do that, a lot of issues can be, rest in place. Like how they ensure that there should be no objection certificate from, let's say, a pollution control board before setting up an STP or an occupancy certificate from BBMP. I think there should be some, additional criteria which they can add as not only a formality, but make it mandatory to get some kind of clearance to ensure that the project is closed and exited. So when RERA is one of it, when you have a closure of the project as a completion certificate, the completion certificate should accompany these primary factors also as one of the criteria that for the project to be completed.
But then there are issues, what is the liability of an MC of such legacy issues? Like there are OCs or NOCs which have been given without adequate setbacks adhered to, or, these kind of issues, not fully compliant, but they have got their OCs or NOCs. So when you have to go for your renewals, especially say fire NOC and others, is when the association is in picture, the builder is no longer there.
Right. So under RERA, what happens? The warranty of the project and the title, especially the land, remains with the developer. So there is no question of him washing his hands away and saying that if let's say if there is some issue with the land or issue with these project approvals, he cannot wash away that his hands saying that I'm no more connected with this. The issue is more particular with these projects which are prior to implementation of RERA. So, and it's not anything easy for projects that have come post RERA also. There are a lot of projects which have been left without an OC, without a Kata, without an STP, without required approvals and no objection certificates from environmental body. So I think there is various aspects which the apartment owners do face, especially the MC when they take over. So it's very important that in the handover, when they are accepting the handover, they do put a disclaimer, or which should go without even having that disclaimer, but they should include a disclaimer saying that any omissions on the part of developer that will not be something that he can pass it on to the managing committee as their liability. So the liabilities will remain with the promoter. All that you are taking over is let's say the handing over of the maintenance, handing over of the management of the property, and maybe receiving the documents as well. So this should be something which the MC should watch out.
So, who owns the CA sites in apartments or gated community, and what exactly is the relinquishment?
See, when you term it as gated community, it's a common term that is used for villas or sites that are formed in lands, which are mostly layouts. Technically, there is no concept of gated community still defined under any of the laws currently. So it's just a name that is a marketing term used by the promoters, but technically under the act, especially for layouts and villas, there is no such concept of gated community unless and until the project plan or the sanction provides for a compound wall. You see in the layouts normally, especially under the Municipalities Act, one layout should be interconnected with another layout. That's the right of ingress and egress. Adjacent landowner or adjacent layout that would be formed would have, each layout has to be interconnected. Unless and until the project has an enclosed compound as one of the precondition, or it does provide for it, only then you can expect that layout or the project to have such gated community. So right now layouts, they don't have such provision, but let's say mixed residential, mixed projects, such as there are few projects which are mixed project apartments as well as villas. Those, because normally apartments come within the compound, those villas end up having a compound within it. So, but otherwise, gated communities, you don't normally find them as an approval to be given in the plan. So that's something that you need to look out for. So the answering to your question with respect to these aspects, one should also look into the aspect whether the site that they're buying does have the required approvals or not. If it does not have such approvals, then you're facing a lot of other issues with respect to project loan, Kata, and OC, and other related problems. So I think one should consider a serious legal advice before purchasing these properties.
How does one find out if there is any loans existing, or the builder has taken loan or mortgages property without the association knowing? Is that a possibility? And how does an association check if there are any legal cases related to the property?
Well, I think your question regarding loans, technically, normally the builders do take a project loan for their area of sharing, but without getting or clearing the project loan to that area of each units, once a sharing agreement has been done, or getting a clearance from the project bank who has given a loan, they're not technically allowed to enter into any understanding agreement or even collect advance from buyers. It's very difficult for buyers to ascertain these project loans unless there is a disclosure by the bank, by the developer. The other way is to ask for a declaration from the builder. Second is to also check the encumbrance certificate, and also ask them about the original documents. So all these aspects would be additional, checklists to ascertain if the particular project has been, subject matter of mortgage or not.
Under this one, what commercial activities are allowed in flats? Can an apartment registered under KSRA ban such activities? Say, there's an implosion of home shares, tuition classes, dance classes, music classes, and these do sort of create friction between residents and managing committees. So what is allowed? Are service apartments allowed, offices, startups, etc.? Can you run businesses?
See, technically, apartments generally in Karnataka, they all come under the Karnataka Apartment Ownership Act. Unfortunately, in Karnataka, they have not made the act mandatory unless and until the promoter of the project or the association registers the project under the act. So the concept of registration, we call that as a deed of declaration. The deed of declaration is an act of registering the property before the sub-registrar, so that the act of Karnataka Apartment Ownership Act applies to the said apartment. So if that is so, under the Karnataka Apartment Ownership Act, it does prohibit registration of commercial apartments or buildings under the said act as a residential use. So it should be a pure residential apartment that can be registered under the act. So once it's registered, any non-commercial activities is not allowed in residential flats, unless and until the areas of the project within the vicinity, the compound of the flats. Let's say it's demarcated with a separate commercial building which is attached to the flats, then that would be a commercial building which is accepted under the project, and it's part of the whole plan. So so per se, apartments cannot be used for non-residential use. So any kind of commercial activity should be limited to if there is any such clubhouses within the said project.
Thank you. Of course, taking this managing committee and residents disputes, there are NCs who go ahead and make policies, pet policies, like disallowing pets or renting out to bachelors, restricting to food preferences. These are slowly cropping up. How does one, address these issues? Even the this one, enforcement of laws like noise or smoking in common areas, that's also another aspect of it. One is MC taking their own decisions, and the other is trying to implement what is for the greater good.
See, this is a very tricky situation because there is no law which entirely prohibits pets within a commercial or within a residential project. What entirely matters is, since it's a private property, a private area, so the bylaws, which is within the control of the apartment owners and which is run and managed by the managing committee, they would be bound by the bylaws. So bylaws again depends on how the bylaws are formed and structured initially by the promoter or by the adoption of all the apartment owners. So if the bylaws do provide for reasonable restrictions, let's say for pets, let's say if a certain project does prohibit pets entirely, then that's the decision of that majority of the apartment owners in that particular project. So the minority of the people who may be pet lovers or may be interested should then decide whether they really want to, buy an apartment or rent an apartment, because then, unless and until they seek for amendment of bylaws, which is again by majority, then it would be very unlikely for that person to overturn or question that majority decision by the majority of the apartment owners. And these bylaws again will be subject to the act. That's again the Karnataka Apartment Ownership Act, which has a draft bylaws, and the act itself. So as long as what you're restricting, such as smoking and in designated areas, noise pollution, which are reasonable and not causing nuisance to others, reasonable restrictions should be something which is acceptable and within the four corners of the bylaws.
There's a question from Mysuru Grahakara Parishad. Under which act should an apartment owners association be registered? Are there any minimum flat numbers specified?
See, that's a mixture of several litigations that's happening in various forums and also High Court. So what matters is if the apartment is registered under the Karnataka Apartment Ownership Act. So what does this act say? Karnataka Apartment Ownership Act is an act which is applicable for apartments that is built in Karnataka. So that is an act exclusively which deals with nitty-gritties of how an apartment should be run, what are the bylaws, and other details regarding the common areas, limited common areas. So it has entire nitty-gritties of what an apartment is and what should have under that particular act. So if an apartment is registered under the Karnataka Apartment Ownership Act, then necessarily that act falls within that ambit of act, and that very registration will give rise to a formation of association. So there is a lot of gray area whether further, once the act is registered under the Apartment Ownership Act, further another association requires to be registered. That's the gray area, because once the apartment is already registered under the Apartment Ownership Act, they say that further registration under the association is not required. But there's too much of confusion, because a lot of apartments which are still registered under the Apartment Ownership Act are also additionally registering under the Societies Act. Some apartments, due to omissions of promoters and developers, which are not registered under the Apartment Ownership Act, they end up registering the association under the Karnataka Societies Act, because they need to open bank accounts, they need to function. So for the functionality of the association, they immediately go get a registration under the Societies Act. But unfortunately, what has happened is the Societies Act does not provide technically for maintenance of apartments as one of the criteria or objectives of the Act. So the recent few decisions of the High Court of Karnataka has said that you can't necessarily register an apartment for the purpose of maintenance of an apartment under the Karnataka Societies Registration Act, because that Act itself doesn't provide for such objective. So technically, you can't register under the Societies Registration Act for the purpose of maintenance. Therefore, recently, the Karnataka government has passed a circular under the Cooperative Societies Act, where the apartments could be registered within the guidelines of that circular. So one should look at the circulars and see that you should comply with that particular requirements.
So, is there a seamless way which is possible for KSRA registration to change over? You said cooperative societies or KOA?
So, as a mandate, apartment doesn't require to be registered under the Karnataka Societies Registration Act. So there are two different aspects. So there's Karnataka Societies Registration Act, and then there's the Cooperative Societies Act. But the whole objective of that act is different. It's not for the purpose of apartments, right? So because associations are formed and associations required to be run and they need to function, what was happening, because a lot of developers were not forming an association, they were not registering the buildings or the project under the Apartment Ownership Act, and forming an association and completing the process, the purchasers were left in a quandary that what they require to do. So I think for the last couple of years, people have just been registering under the Societies Registration Act, saying that okay, it's an association that can be registered under that act, and they've started functioning. But as I said, since the High Court said that you can't register technically an association under the Societies Registration Act because it's not for that purpose, now the circular that has come up requires an association to register itself under the Cooperative Societies Act. So the Cooperative Societies Act is what has been proposed for registration of the associations. But technically, if it is already registered under the Karnataka Apartment Ownership Act, then whether a further registration is required under the Karnataka Cooperative Societies Act is another dilemma that people are facing. So all these gray areas required to be gapped and also to be sorted out very soon.
Is there any, whether it's judicial intervention or government intervention you're expecting in this matter?
It's quite a it's a policy decision that one should take and set in place, because they should probably pass a law which makes a particular act which is applicable to let's say an apartment building or a project without even act of a builder. Because see, what is happening currently, you need the builder or the developer to register a deed or declaration for the act of getting the project within the act, without which that act is not applicable. So I think it's time that they should make it automatic, as long as the building is in place and it's done, as soon as the project is completed, that very act of completion should also deemingly ensure that this building comes under the act of Karnataka Apartment Ownership Act. And it should also clarify whether a further registration is required for the association, or whether it's a deeming aspect that the association is registered and there is a association which can also has the right to sue and to be sued. So because of these lacunas, people are going all over the place, registering an apartment under the Apartment Ownership Act, under Societies Act, now under Cooperative Societies Act. So I think these loopholes requires to be fixed on an urgent basis, so that the apartment purchasers are not the people who are facing the music at the end of the story.
There are a lot of layouts which get bank loans but still not converted or approved. So how are they channelizing this, on what basis?
Obviously, it's a deviation that a particular bank has done. I think for that aspect, I think the RBI should, issue such strict circulars or, directions saying that if a particular project is not approved in accordance with law, then they should not fund the project. So in one way, then it is, such stance taken by the RBI, which would otherwise lead to strict penalties or even losing its license, then I think the banks would stop funding those projects. But it's a give and take issue, because the buyers also require funding. The banks kind of look away with certain deviations the developers does. And in all of these gray areas that exist, sometimes it's very difficult to understand what's going on. So the bank should ensure that they follow the guidelines and the applicable rules before they give a project approval, so that they kind of at the nip of the bud put an end to these kind of issues that one may get into in future.
But can banks be held accountable by the buyer? There is a question on YouTube from Mr. Krishnamurthy. He has been paying property tax since 2009 at Rajankunte village panchayat. But last week he found out that Kata for his site was not done. It has been loaned by IDBI only after giving Kata. So how does...
No, you said the Kata was done or Kata was not done?
He assumed the Kata was done. This one, apparently it has not been, but he says it has been loaned by IDBI only after giving Kata.
So I think, again, we go back to the initial questions that we had discussions. I think it's the A Kata and B Kata and E Kata and the manual Kata. So, this, I think that should be in a panchayat jurisdiction. If it's a legally approved layout, which has conversion and everything, should have e-Kata after payment of betterment charges by the developer, and you would have taken an e-Kata and you would have given them. But I think that Kata, what they're talking about is maybe a manual Kata. It's still a Kata, but it's a manual Kata. Whether a manual Kata or such Kata has been issued after following all the guidelines by the particular authority, that is, if there is a layout plan, if there is a conversion, if betterment charges have been paid, no idea if that has all been looked into. So I think, again, that should be a scenario where there's an e-Kata and there's a manual Kata. So I think there may be a manual Kata which they're passing off as Kata.
There's a question on general power of attorney. How can a GPA be evaluated for an ancestral property? We were talking about this one earlier. If a son grants a GPA, can his family, wife and children claim rights to the property after his death?
I'm sorry, if some would...
If the son grants a GPA, can his family, wife and children claim rights to the property after? So assume the son has given a GPA.
I got it. So see, power of attorney generally, it only authorizes a person to do a certain thing as an agent of the principal. So let's say if he authorizes his family to sell in his absence, then they're just doing as per his instructions. So whether it's a joint family or not, it's something which due diligence requires to be done at the point of purchase. But just because he's given a power of attorney doesn't mean that you ignore the fact or you don't look into the fact whether that property is a joint family property or not. So irrespective of a person gives a power of attorney or he comes forward to execute a sale deed, one needs to look into independently what the source of land and nature of land is.
I think we are coming towards the end of our session. It's been a long 1 hour. There's one final question I would like to ask. In a BDA, two more. Just 1 second. Yeah. So there are these layouts in BDA approved layouts which have come up where BWSSP may not have put up any UGD. So the builder is supposed to build a STP. In many times they do put up STPs, but the capacity may not be enough for the layout. And especially in terms of layouts where it is non-homogeneous or non-standardized gated communities, which are basically plots where people build their own houses. And over a period of time, the bungalows would have got converted into 2-3 floors. So multiple houses in one plot. And the UGD or your STP doesn't support it. So how does one deal with it? And there are times when the property owner will actually channelize his UGD into the same STP and overloads it.
Well, see, this is a very technical question, which I don't think many owners would even be able to carry out a due diligence at their end when they're purchasing. It's something which obviously the promoter has to ensure that he has followed the law and has complied with all the requirements of the sanctioned authority. Let's say if it's a layout, then if it does require an STP, then he should ensure that he does put up an STP as per the requirement. That's the KLD. So that's something which they have to see, and they have to also ensure that power should not be approved unless and until these aspects are complied. So there's a lot of interconnectivity within the agencies that they can put in place to ensure that a layout, let's say a layout as well as an apartment, should not be given a permanent power or a temporary power or a permanent water connection unless and until all these compliances are there. And these compliances, what you're asking, will only be permissible and ascertainable by the authorities who would inspect and ensure all those requirements are done. It would be very difficult for a particular apartment owner or a person who is buying into a villa or a layout to understand these technical aspects. And I don't think even lawyers will be able to advise and except to say that this is a requirement that you need to see, but how to see whether these technical requirements have been met or not, unless and until there's some compliance certificate which is strictly put in place, it would be very difficult to comprehend. So yes, I think the most important aspect is an enforcement and compliance which requires to be put in place very seriously and urgently so that all these aspects can be fixed.
There's one more question on the YouTube. Is Uttara Patra a mandatory document to have?
See, Uttarapatra is also something of a kata and a kata extract. So ultimately, under the context of BBMP, it's the kata extract. It is not a title per se, but it does reflect who is the current owner of the property. So if there is a kata extract that is issued in accordance with law, that is with all the formalities that they've followed with the layout or the site or the apartment, then if there is a kata extract, then that should reflect the current owner, the area, the measurement, and the PID or the property identification number of that particular property. So that kind of reflects all these aspects. So that kind of becomes important and pertinent before you're buying the property.
So the PID number was always mentioned in our Kata, or
yes, in a PID, property identification number is normally given for A katas, as what they call, and doesn't have for a B kata. So if you see all kind of E katas, they do have a property identification which is distinctly mentioned in those katas. And in E katas, in the panchayat limit, you'll also find a photo of the site and location.
Okay. Thank you, Mithun, so much for taking time from your precious time and answering all our queries in detail. Thank you to the citizens watching on Zoom and live YouTube feed. Thanks especially to the citizens who sent in their questions for the experts to answer. These are ongoing concerns with no simple answers, and we would like to hear your thoughts and questions. Please do write to us on bengaluru@citizenmatters.in. Let's keep the conversation going. Thank you.
Thank you. Thank you.
Wonderful session. Thank you.